Good morning, good afternoon, good evening to everyone out there. Thank you so much for joining us here on Immigration and Jobs Talk Show. Well, before we start off with today's discussion, and I'll tell you about the topic, but we have an important disclaimer. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I am Nipasa Pradhan, friends, your host for today. I'm going to be with you for the next hour, and we are going to have a very special time discussing about a very important topic. And I'm sure folks out there would be very interested in today's topic. And we are going to be joined once again by a very esteemed guest. And she's quite a regular in our show. And she is none other than Attorney Prashanthi Reddy from the Law Office of Prashanthi Reddy. Welcome back once again, Prashanthi. How are you doing today?
I'm good, Nipasa. How are you? It's great to be back.
Same here. I'm also doing good and pretty busy. Half year is already gone just like that. And we have stepped into the other half, hoping that it's going to be good for all of us, July. So
Yeah,
how busy was it
absolutely.
for you, June? I mean, with the whole cap season, and it also came to an end a couple of days back.
Yes, so the deadline was Monday, so we were busy until Monday because there were some cases that we were filing online as well. So it
Mhm.
was a pretty busy season compared to last year because last year we had that whole issue with registration and people not duplicate registrations and people not filing. This year I think they filed more cases, so yeah, we were pretty busy. As were most I think other attorneys who do this kind of work. So yeah, it's like
I'm
our
sure. I'm
tax
sure. Busy
season.
month.
Yeah, it's like our tax season. It's just like accountants have tax season. We have our H-1B season where we're usually busy in the month of June, July.
June, July. Very nice. Very nice. I hope it was as expected for you this year as well, this fiscal year as well. What do you say?
Yes, I think so. It was a good year.
All right. All right. So we are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. And friends, today we are going to discuss on this topic H-1B cap case filed. What next? And also, we will discuss about the July visa bulletin. And it's a crucial topic for most of you, I think. So I hope that you will enjoy this whole discussion with none other than Attorney Prashanthi Reddy. And also, we are here to provide you with the latest updates and insights. And wherever you're watching us from, feel free to comment and participate in this discussion. All right. So, Prashanthi, what do you have to say? What can folks expect from us this episode, since we're going to discuss about both the filing season coming to an end, what to do next, and also the July visa bulletin?
Yeah, yeah. So most of you would have filed your H1 cap cases by now. You should because they should have reached USCIS by July 1st. That was Monday. So now that you
Mhm.
filed it, I'm sure a lot of you are wondering what's the next step? What happens next? What do we expect? If we have issues, how do we encounter those issues? So we can discuss the whole gamut of what issues to expect, if any. If you do have RFEs, how to respond to them. When will you get your receipt, your approval? Um, you know, any questions the audience has as well with reference to this will be I'll be happy to answer. And in addition to that, the July visa bulletin has is significant because it has seen some forward movement when compared to all the other months, and it is
Mhm.
towards the end of the fiscal year as well. So, things happen usually just because September is the end of the fiscal year, and then again things happen. So this is when things happen. So it's a good thing to discuss the July visa bulletin because there has been forward movement.
Absolutely.
Yeah.
And we are looking to discuss and dive deeper into this. Sure,
Yeah.
Prashanthi wanted to add something.
I was just saying, and then also we can talk about what to expect for the next fiscal year because that's coming up as well. So these are a few things that we can discuss for sure.
Absolutely, we will, we will. And also, friends, for those of you who are seeing Attorney Prashanthi Reddy for the first time on our show, she has been doing practicing immigration law for 27 years and still counting. So you can definitely check her out and stay with us because you will get to know how sound she is, how informative she is as we go and dive deeper into today's topic. All right, so Prashanti, I got my first question for you as we go into today's topic of discussion, and that is how long does it typically take, to receive the receipt notice after filing an H-1B cap case, and what information does it include?
Right. So the H-1B receipt, we've actually started receiving our receipts for cases that we filed about a week ago. Every cap season is different. Sometimes they delay sending out receipts. But I think this cap season, they've been quite prompt with their receipts. We've already been receiving, as I said, receipts these are just cases filed by mail, not even online. When you file online, you receive the receipt very quickly. But when you file by mail, usually it takes a few days. But we've already received receipts, I think, for cases that we filed about a week ago. So I would say it's taking about a week to get the receipt. If you do premium processing, you might get the receipt even faster. So yeah, just wait and see. By now, most people that filed in the second week of June should have already received their receipts. If you filed premium processing, you would have received even possibly an approval or a request for further evidence. So they're, as of now, at least, acting pretty quickly. And the checks that I've issued for the USCIS fee, the checks have been cleared. All of them have been cleared except maybe 5 to 7 cases. So that's an indication that they're working pretty quickly to roll out those receipts and to take your fees.
Absolutely. So, friends, I
And
hope that you are with us. Yeah.
Nipasa, I just wanted to also say that the second part of the question, what information does it include? Um, it includes the receipt number. And with this receipt number, you can actually go onto the USCIS website and check the status on your case. And so it's important that you have that. It'll tell you the date that the case was received, the date that the receipt was initiated. It'll also give you the name of the company that filed your H1 and also your name as well. And so if you see that there is a mistake in the spelling of your name or your company's name, this is the time to correct it, not after the approval comes, because that becomes uh, an uphill task to correct an approved H1. So you should do it at this point of time if you see any discrepancies.
Right, right. So all information in the receipt is definitely very important. But since we have these dates mentioned, just like you said, it also, I mean, that the receipt holds. Do they have any significance? These dates, the
Well,
date we received, the date the receipt was executed.
yeah. I mean, usually it will, because the date you received, especially if you have a deadline where you have to file the case within a certain period of time. Like if you're filing an extension and your I-94 is expiring, the date that they received it is important, because there can't be a gap in your status. The same thing can apply to a cap case if it's a change of status from an F to a H. Also, the date they
Okay.
received is significant for cap, because they couldn't have received it after July 1st. So, but again, they won't take your money if they received your case after July 1st. They'll just send it back. So, from that point of view, the receipt date doesn't have that significance that it should for cap cases, unless it's a change of status where their status is expiring, and you want to make sure that you filed it before the status expires and there's no gap in status. So, from that point of
Right,
view, the date is important.
right. So earlier it was 30th of June, but since it was a Sunday, a non-working day, it was extended to the 1st of July, right?
That is absolutely correct. Yes.
All right. So let me just quickly say hi to friends out there who have commented. Hi to Shaukat, Akbar. I see them very frequently in our shows. Thank you so much for being frequent viewers. Please don't forget to like and subscribe and also share our content. Also to Pari commenting, first person to comment the video. Thank you so much. It really is very nice. I hope you stay with us. And also to Zoya, we will take up your questions. Hi, Neha. Madhur, Priya, Dharmesh, thank you so much. Just stay with us. We will take up your questions. But for now, let's talk more about the questions I have for you, Prashanti. So this next one is about the documents. You know, what key documents and forms does USCIS review during the processing of an H-1B petition, and how can employers track the status?
So this is something that always keeps us up at night because, we're filing multiple H-1B petitions in a very short period of time because, everybody wants to file in the last moment, even though there's 90 days to file. People will file in June or the second week of June. So
I
that puts a lot of pressure on whoever is filing, whether it be attorney, non-attorney, it's, HR working for the company. Everybody's under a lot of pressure. So
Mhm.
mistakes do happen, and that's why we stay up at night and anxious to make sure all the cases are fee receipted. Because if they're not, then
Mhm.
we're worried that, if USCIS has a zero tolerance policy, they're just it's absurd. But even if you don't mark one column, there's or I understand if you don't send a check out or you send the wrong amount or you don't sign a petition, that's a legitimate reason for them to send a case back, but they're even doing it if you don't tick mark a column, which is ridiculous because that information oftentimes is available somewhere else in the form. So it's not like they absolutely need it. And even if they do, they can always send an RFE, but no, they will not do that. They will send it out not on the first, but they'll send it out on the second. They'll send it back on the second, so you can't even refile it. So that's, one of our worst nightmares as attorneys.
I know.
Uh, so it's important that the forms be filled out correctly. But of course, human error is human error, and sometimes that can't be helped. But it does help if you have a process in place. It does help if there are, two people looking at it or three people looking at it before you file it, and different people looking at it so that you have fresh eyes. But I would say that if you don't get your receipt in the next week or so, that you should go back and look at your petition to make sure, everything was filled out correctly. So they are doing that kind of a review, USCIS. And with reference to documents, um, documents, they want to make sure that you have all the forms, of course. If you're missing a page, then of course also they can send it back. And basic
Mhm.
documentation has to be submitted, like degree copies and passport copies. So if you have not submitted them, then expect that you'll get an
Mhm.
RFE. If you have degree copies and the degree is not related to the job that you're doing, and you haven't sent out an evaluation, or you need to send out an experience letter to show that you have the equivalent of the degree required,
Mhm.
then also expect an RFE. So these are some of the key documents where you'll get a request for further evidence. Um, also, how can employers track the status? As I said, once you get your receipt, there will be an SRC number or IOE number. So you can put that into the USCIS website. There's a USCIS case status page. Put that in, and that will give you the status on your case. So that's the best way to
Okay.
track. Of course, if you're filing online, then you get um, updates, you get
Mhm.
emails, you get text messages if there is an update on your file. Though I heard that there's a glitch in the USCIS system, and they're sending
Okay.
out one of the attorneys said that they got like 400 emails overnight. It was some kind of a glitch in
Oh,
the system, and they kept producing emails which were not relevant. So hopefully that won't
okay.
happen to you. But yeah, that's the best way of tracking your case.
Thank you, Prashanthi. Well, you told us about the basic documents, but you were also talking about the forms. Maybe is there a checklist? Some of them which have to be there in the process.
Yeah, so you have to send out the I-129 form, the I-129H supplement form, and the I-129 DC. And you have to make sure you send out all the pages, and you make sure that you sign the I-129 petition. So go back and check. And the I-129H petition has to be signed in two places. And if you have an attorney, then there'll be a G28 as well, which will be signed by both the petitioner and the attorney.
Okay.
And of
So there
course,
you
if
go.
you have
There you have
premium, yeah, if you have premium processing, Nipasa, you'll have the I-907, which has to be again signed by both attorney and the company as well. So if you send out, and also checks, the checks have to be for the correct amounts. They have to be separate check,
it.
for each amount. They're separate checks, so you'll have four different checks. If you have premium processing, then you might have 5 different checks. So make
Mhm.
sure your checks are dated correctly, signed, and have the correct amount.
Okay. Thank you so much. What is a G28 you were saying?
Oh, that's the attorney representation form.
Okay, okay. And the I-907 you said?
That's the premium processing form. The premium processing. So
Okay,
if you want to fast track your case, you can file premium processing by paying the additional fee, and then your case will be responded to. They'll respond to it in 30 days, and it could be a request
okay,
for further evidence or it could be an approval. But they usually respond in 30 days.
okay. Thank you so much. Thank you so much for the detailed, elaborative explanation. I'm sure folks out there are pretty clear about this now. Well, we will take up your questions. Thank you so much once again for joining us. We are going to take up your questions. Dharmesh and Sarika, thank you so much for commenting. Well, my next question to you now is, Prashanthi, about, what are the common reasons for receiving a request for evidence, the RFEs, during the H-1B petition process, and how should one respond to these RFEs?
Right. This is an apt question because we're talking about what next. We hope that
What
all
next?
of you will get approvals and nobody will get an RFE. But this is the possibility of what will happen next, request for further evidence. And, even if it doesn't happen, it's good to have this information so that you'll be less anxious about the process. And if you do have an issue and you do have a request for further evidence, you won't get too anxious and you'll know how to respond to it because it's not the end of the world. An RFE is simply USCIS asking for additional information. But in addition to an RFE, you could also get a notice of intent to deny. That's a NOID, and that's a little bit more serious than an RFE because they've already kind of made up their mind to deny the case, and they're sending you a notice that they intend to deny it and that they're giving you a chance to tell them why the case shouldn't be denied. So an RFE is not the same. It's just a request for further evidence. So there could be many reasons why you get a request for further evidence. As I said, it could be that you didn't submit the basic documentation that you're supposed to, like your degree copies, or you need an evaluation and you didn't an evaluation if you have a foreign degree, or if you're trying to do a combination of education and work experience to get the equivalent of the degree that you require. Perhaps you didn't get work experience evaluation done. It could be that maybe the job, it's not clear to the USCIS officer whether the job qualifies for a H1, whether it's a specialty occupation or not. Sometimes when you use level 1 wages, it's possible that you'll get an RFE because they want to make sure that the job is actually the job that's being offered is actually a level 1 job. It's an entry level job. So they will ask further questions and ask you to show them how you calculated and how you got to
Mhm.
that level 1 wage. So that could be another reason. It could be that LCA was not filed properly, or there was some issue with the LCA. Maybe it was a typographical error. Not much you can do if that happens. So let's hope all your LCAs were filed properly, and you check that beforehand. So these are some of the reasons. Also, if you're a student and you file for a change of status from an F1 to a H1, you might get a student RFE, which is basically maintenance of status. And if as a student, you were on CPT, you could get a RFE saying, prove why CPT was required by your school, justify what courses you took and how that's related to the curricular practical training, the job that you did on CPT. Also, it could be maintenance of status in the sense that they want to make sure that you're a full-time student, and they want proof that you are actually going to school and attending the number of in-person classes that you need to attend. So these are some of the few reasons, common reasons for receiving a request for further evidence.
Evidence. And about responding to them?
Be calm and responding to them, and make sure you read the RFE properly, read between the lines. Sometimes the USCIS has a lot of information that is not useful to you, and then they'll ask the actual question in the middle of all that useless information. So you may have to make sure you don't miss what they're actually asking for, and they're not, these RFEs are not really written well, so it might sometimes take two readings of it to make sure that you haven't missed anything. Respond to everything that they're asking for. Don't choose to respond to some information and then just presume that the other information is not important and you don't need to respond to it.
Mhm.
Your case will get denied if you don't respond to all the issues that they have brought forward in the request for further evidence. I think those are a few pointers on how to respond to an RFE.
Thank you so much, Prashanthi, for that tip. And definitely, I think we always need to, keep calm in no matter what situation life throws at us. So main thing is that, of course, and apart from that, the information, all the important information should be as clear as possible. So all the best, friends. And yeah, hi to Amar. Thank you so much for your question. We will take that up very soon. Just stay with us. And also to Sawan, thank you for joining us. So, Prashanti, it's so inspiring that you have been, in this business, in this job for over 27 years now. So, what inspired you to start your business, and what was your initial experience like?
Well, I think I came to the US like any other immigrant did on a student status. So, coming on an F1 myself and going to school here, went to law school here. Um, I was thinking as to which law would best serve, I guess, my community and where I could be the most relevant, possible. And I felt
Mhm.
that it was immigration law that would do that best. And also, I took a few courses in law school with reference to related to immigration law. So I thought that was most interesting. I was not very interested in corporate law and the other kinds of law. This was more attractive to me, and also, as I said, it seemed to be more relevant. And that's why I took it up, and yeah, and still continuing and enjoying the journey.
So nice. Making dreams come true, one case at a time, huh? Prashanti, literally.
Absolutely, yeah.
So nice, so nice. Anyway, let's move on. Now, I have another question for you, and that is, what are the possible outcomes, for H1 outcomes of an H-1B petition, and what steps should be taken if the petition is denied?
So the possible outcomes is a request for further evidence, a straight approval, or a notice of intent to deny. And then once you respond to either the notice of intent to deny or it could be also notice of intent to revoke if they find some issue with reference to fraud or with reference to your registration process. They find some fraud there. They could just send a notice of intent to revoke. Um, and there's a difference between deny and revoke. Uh, if you a notice of intent to revoke is more serious than a notice of intent to just deny the case. Usually involves, as I said, fraud. If you get these notices, we just discussed how you should respond to them and how to stay calm and educate yourself so that you will not panic and you know what to expect when you get an RFE and how to respond to it. If it gets denied, and that is also a possibility, and there are many, many reasons why a petition could get denied. Could be due to oversight. It could be that you didn't respond to the RFE properly. It could be some issue that has come up in an RFE, but you were not able to fix it. And therefore, then they deny the case. I mean, if the case gets denied, then you can, of course, file an appeal or you can file a motion to
Mhm.
reopen. Both have to be done within 30 days of the denial notice. You continue to be in status while your appeal is pending or while you decide whether you need to file or not. So you have that 30 days to decide whether you want to file the appeal. Or you can continue to be in your status, whatever status you're in, because that doesn't change. And if you are falling out of status or if you have already fallen out of status, by the time the H-1B response comes in, then you should think about, you have the 30 days to wait and see whether you want to file an appeal. And if you choose not to, then you have to leave the country immediately, because there is
Mhm.
unlawful presence which will start accruing. And if you stay outside, if you stay out of status for more than 6 months, then you might have a problem with that. Uh, because if you then leave the country after being out of status for more than 6 months, that is, if you accrue unlawful presence, if you leave, then you won't be able to come back. You'll be barred from coming back into the US for the next 10 years, and you won't be able to get a visa either, right? So these are some of the things to keep in mind on a denial. So I wouldn't stay out of, but if you do decide to file for an appeal or a motion to reopen, then you can stay in the country while that appeal is pending or the motion to reopen is pending. And then once you hear back and you get a response, if it gets approved, great. If it gets denied, again, you need to leave immediately so that that unlawful presence clock doesn't start ticking, right? So the difference between a motion to reopen and an appeal is a motion to reopen goes back to the officer and the USCIS that has decided your case, and an appeal will first go to be a motion to reopen. That means it will go to USCIS, and if they still don't want to reverse their decision, it goes to the Administrative Appeals Office. So this is looked at by a different body, and I
Mhm.
must tell you that it's um, very unlikely that an appeal gets overturned, meaning an appeal gets approved, that a USCIS decision gets overturned. There are only some instances where that happens. But you should definitely, if you think that it was wrongfully denied, you definitely should go for an appeal, um, and put all the issues forward as to why you think that the case should not have been denied.
Right. Right. Just stay strong. And I think if you think you still have a chance, you should definitely go for it and prove yourself right. All the best, friends.
Yeah.
And
Also, I think if you um, get an RFE and you know that the RFE is difficult to respond to, or you think that will not get approved, because you know when you get an RFE as to what issues they're asking and whether you're able to respond to them or not. I would suggest that while you're still in status, at that point, if you're in status, you should try and safeguard your status and maybe file for a change of status while your H1 is still pending and not denied, because you still have a pending status and you have the opportunity of filing for a change of status so that you can salvage that status that you have, because once it's denied, then not much you can do to then at that point file for a
Mhm.
change of status. Something to keep in mind.
So true, so true. So work on it, friends. All right. And Shanti, I think I'll just have one last question on this, and then I'll have some the July visa bulletin questions after the break, maybe. But I mean, the next question that I have for you is, what is the process for scheduling a visa stamping appointment at a U.S. consulate or embassy, and what documents are required in hand? If we
Uh,
could count the documents.
Right. So the documents are usually given by the consulate. They'll send you a list of documents, and usually those documents will be, the copy of the petition is most important. The petition that was submitted to USCIS. They have a copy, but it's good for you to carry a copy as well. Your offer letter from your employer. You should also take your original degree certificates, and if they require any additional information, I would say keep a copy of your employer's tax return, and have that sealed so that you don't, because it's a confidential document, your employer may not want you to look at it. So you can hand over a sealed copy of your tax return to USCIS. Usually that's all that's required. And if they need anything further, they will ask you for it.
Okay. Thank you, Prashanti, for making that clear for us. We'll quickly take a question, and this is from Amar from the audience. And Amar has written to us in YouTube. He's saying, "Hi, recently I have changed from H1 to H4. My previous H1B stamped visa is expiring in September 2024. Can I travel to India and come back with H4 approval without going for stamping?"
No, you cannot, because you have to have a H4 stamp in your passport, a visa stamp if you want to travel back on a H4. They won't allow you back on a H4 without a visa. But you can, of course, you can leave the country on a H4 and then come back on a H1 if you have a H1 approval to go with your H1 visa.
Okay. All right. All the best, Amar. And the next question, we'll take this one. This is from Sean. I am on OPT EAD and my H-1B has picked up in the lottery, was picked up in the lottery. My employer raised an LCA but didn't file an H-1B because I couldn't secure a job. Can I still use the lottery selection?
No, unfortunately, there is a deadline of 90 days to file your H1 when you're selected in the lottery. So you'd have to restart the process, unfortunately, next year.
Yes, Sean. All the best for next year. I think that is the only option you have for now. All right, so Prashanti, we'll just go for a quick break now and we'll be back. Friends also out there, we'll just go for a short break and we will be back to discuss on this topic once again. So thank you so much, Prashanti, so far, for sharing such valuable information. And also, before we continue, I just wanted to remind our viewers that you could reach out to Attorney Prashanti for any immigration related queries and you can contact her. Her details are on the screen. Um, so you can contact Prashanti, email her prashanti at reddyesq.com. You can also call her 2354 1010. That is her number. It's displayed on the screen. You can note it down. Again, I repeat, 212-354. And Prashanti's email address is prashanti at reddyesq.com. And if you want to know more about Prashanti and the law office of Prashanti Reddy, you can definitely go visit reddyesq.com. And don't go anywhere. We'll just go for a short break now, and we'll be right back on Immigration and Jobs Talk Show.
IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everyone, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, your host for today, and this is the second half of today's webinar we're having with none other than our guest, Attorney Prashanthi Reddy. And today's topic of discussion is H-1B cap case filed, what next? And the July visa bulletin highlights. So far we've, I think, covered what are the next steps we could do, after the cap case has been filed. And now it's time to go and get to know better about the dates on the July visa bulletin. So Prashanti, once again, everyone, welcome back. So Attorney Prashanti is here and she has been discussing a lot about this whole thing. So I hope you were with us. But even if not, you can always go back and listen to this whole stream, even after we have streamed live. And don't forget to like, share, and comment. Uh, Thank you so much for all your questions. Also, we will take them up and stay with us, friends. So, Prashanti, I think we should definitely cover up some questions on the visa bulletin. So my question to you would be: how do final action dates and dates for filing applications differ in the visa bulletin, and what steps should applicants take when their priority date becomes current?
Nipasa, that's a great question. Let's first discuss what the July visa bulletin says, and then I
Sure.
will come to that question, so people will kind of understand where we're going with this. So according to the July Visa Bulletin, the employment-based final action cutoff dates um, are going to be used. And then coming back to your question, there are two kinds of tables. There is the final action date table, and there's a dates for filing table. And the USCIS lets us know every month whether they're going to be using the final action date table or the dates for filing table. The difference between the final action date table is the actual dates for your visa. So that means you'll immediately be able to qualify to get a green card and you can file a 485. The dates for filing table is basically you're filing in advance of the date actually becoming available. And they're allowing you to file in advance because they think that by the time your 485 actually gets processed, because there is a processing time for the 485, they expect that your date will become current. So that's why they're allowing you to file in advance. So usually in the first few months of the fiscal year, the USCIS tends to use the better table, which is the more advanced table, which is the dates for filing table. And as the year goes by, USCIS then starts using the final action date table. So right now, as we are towards the end of the fiscal year, remember fiscal year is October to October. As we are towards the end of the fiscal year, we have started using, USCIS has started using the final action date table to determine the cutoff dates. So for this July Visa Bulletin, there is a huge advancement for EB1 category. We're only going to talk about employment based for now. EB1, India has advanced by 11 months. That's almost a year. And now the new date is February 1, 2022. China has advanced by a modest period of 2 months only to November, and all other countries for EB1 are correct. So if you were born in any other country other than China and India, no matter what passport you hold, your dates are current for for the employment-based category 1. EB1 is extraordinary ability. EB1 is L1A based people, multinational executives. These are all EB1, come under EB1. Now, for EB2 category, employment-based category 2, which is people who have advanced degrees, master's or a bachelor's plus 5 years. India has advanced by 2 months, so modest advancement to June 2012. China advanced by 1 month to March 2020, and all other countries are not current. EB2, they're also backlogged, but they've advanced by 2 months as well, and the backlog is not that bad for other countries. It's March 15, 2023, which is huge, right? 2012 versus 2023. Yeah, there's a
Yeah.
big difference. So EB3, which is skilled workers and professionals who have a bachelor's degree, very, very small advancement of 1 month to September 2012. So EB2 and EB3 are running neck to neck, June 2012 and September 2012. So, and all other countries also have actually retrogressed by 11 months and 3 weeks to December 2021. So not so bad for all other countries, but they have retrogressed significantly by almost more than 11 months. So that is what it is in July. For August, what we can expect is that there will be retrogression in EB3 for sure for India for the month of August. And we don't expect any forward movement. I'll be surprised if there's any forward movement for the month of August. So that's July and August for you.
Okay. Oh, okay. And what steps should applicants take when their priority date become current? That's the
They
second
should
part of the
immediately file
question.
their 485. File for adjustment of status because you don't know whether it'll remain current or not and how long it'll remain current for. So you usually get information about the visa bulletin a month before. So you have time to prepare. So you should immediately contact your attorney to start the processing. so that you'll be able to file the following month when your dates become current. And some things to keep in mind is, or to get ready, if you expect that your date will become current, or if you already know that it's current, is immediately go get your medicals done. Get your information, such as your birth certificate or non-availability certificate, get that from your country of birth if you don't have it. These are some things that you should always keep ready because it takes time to get them. If you don't have a birth certificate and you're using a non-availability certificate, make sure you get secondary evidence of your birth. So your 10th grade transfer certificate if you're an Indian national, letter from the hospital, maybe affidavits, birth affidavits from your parents or other relatives, older relatives who were alive at the time of your birth. And those have to be notarized. So these are some things that you can get ready ahead of time.
Okay. All right. All the best, friends. Now, moving on to the next question, Prashanthi. Like, what criteria do consular officers and USCIS use, to determine if an applicant is documentarily qualified, and how does the order of priority date affect visa allocation?
Documentary qualified, they make sure that all the documents are there. So the important documents for adjustment of status is the birth certificate, the passport. They want to make sure that they're allocating you to the right country.
Mhm.
Because visa numbers, as we just saw, as I just said in the visa bulletin, are not current, are different for different countries because some countries are oversubscribed. Even though all of them, with reference to allocation, coming to that next question, every country is allocated 7%. So, the allocation is same no longer, no matter what the size of the country is or what the demand is. And unfortunately, India and China having large populations, and the demand is higher, that 7% is not enough for them, and therefore it's always oversubscribed. So while someone from Iceland or even Bangladesh or Pakistan or other countries, any other country other than India and China, they are able to file their green card and get it ASAP. Indian nationals have to wait for many, many years to get their green card. So that seems unfair, but in a way it's fair that all countries are allocated the same numbers, 7%. But it's unfair because the demand is higher and the population is higher for some countries. So I think what needs to be done is that overall the restriction on green card numbers has to be removed. So everybody can go through the process
Yes.
and get their visas at the same time. So that's how they determine, applicant, whether they're documentary qualified or not. They want to make sure that all the documents are there, and that's how they allocate the visas. With reference to document qualification, of course, you have to make sure that your forms are filled out correctly, your checks are filled out correctly, and the forms are correctly signed, and the basic documents are submitted. Medicals are, I would say, is one of the basic document, but they don't send the case back for medicals. They will definitely send a request for further evidence. You have to make sure you get your COVID vaccine, so that has to be documented properly. Um, and if your case is based on an I-140, for example, then you have to make sure you submit the copy of the I-140. So that's an important document to submit as well.
Right. Thank you so much, Prashanthi, for taking that up. And I'm sure it's much clearer to the audience now. Also, good news, I think, for Telugu speaking audience is that, we are going to start with our immigration and jobs talk show in Telugu, another channel very soon. So I hope you stay updated and subscribe to our channel to get to know more about this. All right. And Prashanthi, do you speak Telugu yourself?
I do. That is
Oh,
my
nice.
mother tongue is Telugu. Yes, that's my native
Also nice. So
language.
I hope that we can have you also in Telugu immigration and jobs talk show for sure. We will look out for that too. Something to
I
start,
can't
friends. So
promise, but
definitely,
I'll try.
yeah,
Yeah.
sure, 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 we will. All right, I think we'll take up a few questions from the audience because we've been speaking a lot since the
Yes.
beginning of this webinar. And Zoya must be waiting. She was one of the first to comment. So, Zoya on YouTube is asking, as I navigate our H-1B cap case, what proactive measures and contingency plans should I consider to address potential requests for evidence or denials amidst the current regulatory uncertainties impacting visa adjudications?
Um, right. So I think what she's talking about is the new proposed regulations that are pending and have not yet been, they're still, they've been published, but they have not been implemented as yet. So maybe Soya is talking about those proposed regulations. If you've already filed your petition, then the proposed regulations, the way it could impact us, it could make it, um, especially if you're an IT consulting type, if you're in an IT consulting type scenario, and if you have not submitted a purchase order or work order or other proof that you actually have work for your employee, then they might ask for that information. So I would keep that ready in case you get a request for further evidence. And you have to make sure that you show them that you had the work from the date of filing the petition, not from the date that you got the RFE. So you have to make sure that those purchase orders were available even or were dated as of that time period from the date that you filed the petition. So that's something to keep in mind. They're also getting a little stricter on how they, um, stricter and easier, both on how they are going to define specialty occupation. So if you have a case where you're not sure whether or if it's kind of borderline, it's not clear whether it's a specialty occupation or not, requiring a bachelor's degree in a specific field, then you should keep that response very ready to show that there are other jobs, other industries, or rather other jobs in the same industry require a bachelor's degree. So show proofs, look out for job postings on DICE, etc., to show that it's common in the industry to require a bachelor's degree. Prepare a nice write-up to show why your position requires a bachelor's degree, what are the complexities of the position, and why a person without a bachelor's degree can't actually work in your position. So these are some of the things that you can proactively do to keep documents ready to ensure that if you do get an RFE, that it will be responded to properly. And if you don't have an attorney, make sure you have an attorney to. If you do get an attorney, don't an RFE, don't try to respond to it on your own, because these
Yes.
RFEs are complex, even though they seem simple. There's a lot of hidden meaning and information that they require when they send out a request for further evidence.
True. So I think you should definitely have an attorney to represent you, and all the best. Thank you so much, Zoya, for the very important question. I think it brought some more light to our webinar today. Thank you, Prashanthi, for taking that up. All right, moving on to the next question. This is from Madhur Priya. I am on F1 and I have my STEM OPT valid till February next year. My HR informed me that my case was selected in the fiscal year 2025 H-1B cap lottery and that they would do the filing in the coming weeks. There's a continuation. After they file and the petition gets approved, what are the steps to change the status from F1 to H-1B? Does the status change automatically in October 1? And will it be possible to fully utilize my STEM OPT employment authorization until February next year and then change status to H1? Very long question.
I think yeah, why don't you take one question at a time?
Right. So let's do that.
So I'm on F1. Is that the first question? Okay, I got selected for the H-1B. I'm on F1 and I'm on a STEM OPT valid for till February of next year. HR informed her that the case was selected in the CAP and that they would be filing in the coming weeks. That doesn't make sense, Madhur Priya, because they should have filed it already. The deadline to file it was July 1st. They should have received your case by July 1st. So please reach out to your HR. Maybe there was some miscommunication, or maybe they've already filed it and you are not aware of that. But the deadline was to file was July 1st. Now let's presume that they have filed and all goes well. What are the
Yes.
next? What are the steps to change status? So your employer has to file for a request to change status. So if there are two ways of filing a H1, you can either do the H1 for consular processing, meaning that you don't want a change of status, or you could do a H1 for a change of status. You can request a change of status, and USCIS will grant that change of status as of October 1st or as of the date that your H1 gets approved, whichever is later. And automatically your status changes to an F1 then. If you do not want to change your status automatically and you want to continue on an F1 for some
Mhm.
more time, then I would suggest you file your H1 for consular processing. What this does is this allows you to continue to be on an F1 and then at will change to a H1 by leaving the country and coming back on a H1. So you'd have to leave the country, apply for a H1 visa and come back whenever you wish to change to H1 status. So I hope that answers that part of the question.
Me too. Me too. Madhurpriya, I hope you got your answer. And I'm sure you should find out more about what your status is with your employer for sure. All the best. Thank you, Prashanthi, for taking that up. Now, the next question is from Dharmesh. Dharmesh is also asking on YouTube. I got selected for H-1B this year, but it was selected under regular cap and not master's cap, even though I did my master's from US, not bachelor's. Is it going to be an issue?
No, absolutely not. You should be happy that it got selected and hopefully your petition was filed on time. It doesn't matter. It got selected. That's what's important.
There's another question Dharmesh is asking. Can I file for new H-1B cap through one employer while on pending H-1B application with another employer?
So you have to use the registration notice and the employer that filed for that registration and file the H1 through that employer. Once that H1 gets approved and once you start working on that H1, then you can always file a transfer to another employer. But in order to be cap exempt, you have to first apply for a H1 and get it approved before you can change to or file for a cap exempt H1 because you've already been counted towards the cap. But you're not counted towards the cap until the H1 actually gets approved.
Okay, that's a little tricky, but all the best, Dharmesh. Uh, I hope everything will work out well for you. Moving on, let's take up this next one. This one is from Vishnu Vardhan, also on YouTube, asking how long does it take for the H-1B visa for consular processing in regular processing for California Center?
Uh, it can take a
Sounds
few months if you haven't done premium processing. It doesn't matter whether it's consular processing or you're filing a change of status. I think they pretty much take the same amount of time. Maybe 4 to 5 months is what you can expect. If it comes faster, that's great. USCIS is not known for maintaining its processing times, so they can vary. So that's why I don't want to tell you for sure, but on an average, maybe a few months, about 4 months or so is processing time at all the service centers. It doesn't matter where now.
okay. All the best, Vishnu Vardhan. This is quite a familiar name. I'm sure you're one of our regular viewers. So thank you so much for commenting. And don't forget to like, share, and subscribe if you haven't already. Thank you, Vishnu, once again. And this one is since we're streaming live also on Prashanthi's channel on YouTube. This is from Prashanthi's channel asking. This is from RK on YouTube. When will they announce if there will be a second lottery?
Right, that's the question of the hour. Everyone wants to know that.
Since forever,
Uh,
not just today.
yeah,
This has been in the minds
yes,
of so many
all
people.
our shows and all our shows, they are definitely asked this question. So we don't know. We are expecting any time now, starting now, because they've already received all their H1s. They have to document them, do an inventory, see how many were filed, and if they have any numbers remaining. So from now to any time in September is I know it's a long window, but it could be any time. But usually by September, they should announce it, September, October,
Hopefully
before the
soon.
fiscal year ends. Yeah.
Yes, yes. There's another question from RK asking, how has layoff impacted H-1B filing this year?
Yes, people have been saying that there haven't been that many H1s filed, that the market is not that great. And other companies that I spoke to are saying that since the market is not good, a lot of companies uh, did their registration, got the registration approved, got selected in the lottery, but didn't actually file the H1. So there is some hope that there'll be a second lottery because of that. So let's see. A lot of people have said that they are not finding their H1 this year because of the layoffs and because of the way the market is, and because presumably there are people available in the market to file H1B transfers because there are people who are out of job. So there are people available, so they don't have to file a H1 for to bring a person from outside the country. But I'm presuming the on the other end, on the other side of the argument, you're actually filing your H1 for next year. You're not really filing for this year because by the time you get the approval and the person comes in, it's really next year. So most employers who file will file for a future date for what they expect to be their demand next year. So in a certain way, that should not impact then what the economy is this year, right? So as long as they have an expectation that they have a lot of requirements for next year, people will still file. So, I've said both things. Let's see what actually happens. There is an
All
argument that
right.
goes both ways, but let's see.
All right, we will. We will. All right. Next question. This one is also on YouTube. Thank you, Prashanthi, for taking that up for RK, by the way. RK, thank you so much for your questions and for commenting. So this next one is from Pedo Ju asking, hi, what are the chances for H-1B second lottery? We just answered that to RK, and it's the same answer for you too, Pedo Ju. Thank you for your question. Moving on to Dipti, this next question. Hello, can you please explain in detail what is the difference between a cap subject and cap exempt H-1B petition? And it would be great if you can explain with examples. Wow.
Wow, we'll have to do like a whole session for this, Dipti.
Um,
Next
just
session,
going to say
next
that.
section is going to be on this topic. But let's try to do it as because we're running out of time also, and we want to answer as many questions as possible. Try to do it as quickly and short and sweet format. Um, Cap subject is those people who have never filed a H1 before. They are subject to the cap. And so, for example, if you're on an F1 and you've never filed a H1 before, you've never been on a H1, you would be cap subject, and you have to file under the lottery. Cap exempt is if you've filed previously in the last 6 years, if you've been on a H1 before, or if you have a H1 approval before, even if you've never actually worked on a H1, even if you have an approval, you would be cap exempt. You would also be cap exempt if you are working for a cap exempt organization. So a um, nonprofit research organization, a nonprofit organization that is related to an institution of higher education. So, for example, a teaching hospital or institution of higher education, such as a university, a research organization, nonprofit research, or nonprofit governmental organization. These are all cap exempt. So if you work for any of those, even if you're not working for them directly, but they are your end client, then also you're cap exempt. So I hope that answered your question.
Definitely. Dipti, I would also suggest you should check out our content in our channel because we have definitely covered this earlier in some of our different webinars, also with Prashanthi earlier. So check us out. We are Immigration and Jobs Talk Show. You can check us out on YouTube, LinkedIn, Facebook, and Twitter, but mostly on YouTube. You'll get all our content. Just check us out. All right, next one. Quickly, we will take up a couple more. This is from Varnika asking for a friend. She is living in US currently on F2 visa and is looking for H-1B cap exempt jobs. Number one, is she eligible for H-1B cap exempt jobs? And number two is, if yes, then how can she start looking for it?
Anyone is eligible for a cap exempt job as long as they qualify for the job and it's a specialty occupation, well, how do you start looking for it? You go to Dice, uh, or go to Monster, or go to Headhunters, and work for, I just mentioned which type of companies are cap exempt. So you should look for those nonprofit research organizations, or the working for a university or working for a hospital. These are all cap exempt organizations.
Right, Varnika. I'll also love to tell you, please look out for us as well. We are www.highrightypeople.com if you're looking for project placement or anything as such. I think you should definitely tell us more about yourself and we'd love to help you out. All right. Thank you, Varnika, for your question. This next one is from Vernon on YouTube. I have a query. Does H-1B master's quota have the lottery system? Or lottery system is applicable if it reaches to 20,000, or only the regular cap has the lottery system?
So the way it works is, if you qualify for the master's cap, they will put you in the lottery for the 20,000 numbers. And then if you don't get picked in that first lottery, which is the master's lottery, which has a separate 20,000 numbers for the lottery, you'll get put into the regular cap, which is the 65,000. So you get a shot at, you get two picks at the lottery. So they'll put you twice into the lottery system. That's how it works. So the chances of getting a H1 lottery picked are much higher if you have a US master's degree from an accredited institution.
Okay. All the best, Vernon. Now we'll take the last question. There are two questions actually from the same person. This is Zohan on YouTube. As I explore ways to strengthen my H-1B cap case application, how can I leverage across border partnerships and collaborations between universities and corporations to enhance competitiveness, specifically in fostering innovation and facilitating knowledge transfer? It's just one question, a long one.
Yeah, I don't know if this is immigration related. I don't think it is. I mean, how do I foster competitiveness? Let me read it again and let's see if it's anything related to immigration so we can answer it. Uh, yes, the person is on a H1. So we are dissecting the question. Yes, the person is on a H1, and they want to know H1 cap. So once you're on a H1, you have to work for your employer. Obviously, you cannot do business on your own and try to leverage those cross-border partnerships that you're trying to leverage. You might have to be on a green card or at least on a H4 EAD to be able to be an entrepreneur and leverage those partnerships and collaborate, as you said, between the universities and corporations. It all seems like this person is an entrepreneur and they want to do something in the educational field and in your foster international relationships. Unfortunately, on a H1, you have a very limited scope of work because you have to work for that particular employer. But if you get onto a H4 EAD or you're on some other kind of EAD, you can definitely do that. Or if you find for a green card and it gets approved, definitely go ahead and follow that dream that you have of whatever you want to do. But on a H1, you are limited.
True. I think, Zohan, you should definitely look out for more options for you. I mean, I'm sure there are so many more. So, all the best. And I'd say you should definitely consult an attorney to get proper guidance on how to go about it and maybe even get into the correct sort of visa, which would be very, very suitable for you. All the best. And thank you so much, Prashanthi. But before we go, if you could just leave all our viewers with a small tip, maybe for the day, immigration tip for the day would be great.
I think the only immigration tip that comes to mind now with the H-1B season getting over and, with possible new regulations coming into play, I would say if you get an RFE, use an attorney. Don't try to respond to an RFE on your own. Keep an attorney handy so that if you do get an RFE, they can respond. Of course, if you get an approval, great. And if you have any questions, I'm always here.
All right. And one last question I have for you is, Prashanthi, will the upcoming election affect the H-1B scenario? In short, what do you
That's a
have to
big
say?
question. Yeah. Yes, absolutely, it will. So not only the upcoming, if especially if the government changes, it will. If the Republicans come, they are not immigration friendly, so it will have a major impact on all kinds of non-immigrant, immigrant, every kind of immigration process will be impacted somehow or the other, to some extent, some greater and some less. In addition to the regulatory changes that we're expecting, which will also have a big impact, this will have also an impact because it's the way USCIS will actually process cases. There's no change in the law, but the way they interpret the law change around. USCIS, after all, is a government organization, so they change as per the government. The what the government says. So there will be a big impact, and not for the better. So
Well, I think it'll always be a surprise for us, but I think we should always stay hopeful. And with this, I think we're wrapping up our show for today with Prashanthi Reddy. Thank you so much, Prashanthi, for doing this once again this week. It was lovely having you, as always.
thank you, and it was lovely being here, and I'll see you again next week.
We'll definitely, for sure. All the best and have a great day ahead, Prashanthi. Thank you. So
Thank you.
thank you also all you viewers out there for joining us. And if you want to contact Attorney Prashanthi Reddy directly, her details are on the screen. You can call her up on the number 212-354-1010. And you can even email her directly, prashanthi@reddyesq.com. And definitely visit her website to get to know more about her and her law firm. Uh, that is the law offices of Prashanthi Reddy. That is reddyesq.com. All right. Thank you so much. Thank you so much once again, friends, for doing this, for joining us today in our show. We were streaming live on YouTube, LinkedIn, Facebook, and Twitter, almost coming to an end. But if you're going to watch this or are watching this video after the stream has ended, you can always ask your questions because we have our experts who would be more than happy to be able to help you with an answer or to at least guide you on how to go about it. Thank you so much. And we are Immigration and Jobs Talk Show. That is our handle. If you haven't already subscribed to us, please do, because we keep coming up with these very amazing discussions. And in fact, today, in another hour, I'm going to be back again with another guest with us, and we are going to have another very important topic to discuss. So don't forget to join us then as well, 2 p.m. EDT today. All right. Thank you so much. And if you are looking for a project placement, EAD, green card, anything related to immigration and jobs, please do not forget to contact us as well. Contact me. In fact, you can have my number. My phone number is displayed on the screen. You can call me. You can even WhatsApp me on this number. My number is 408-335-6444. You can email me about yourself or your status, your job, whatever you're looking for, and write to me. And my email address is nipa@higheritpeople.com. And definitely to get to know more about us, check out our website, www.higheritpeople.com. Thank you for joining us today. This is Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com